Judge who had overturned the state's ban on gay marriage in August. District Judge Vaughn Walker ruled Prop 8 unconstitutional, a move which would have cleared the way for same-sex marriages to resume in California. That is, until Prop 8 supporters appealed. They claimed Judge Walker, who is gay and in a long-term relationship, should have recused himself.
Hello, I'm Dr. Leigh Davis, and this is The Legal Analyst, and I am your legal analyst. Today, we are talking about what is going on in California with the current ban on gay marriage. Now, Proposition 8 supporters in California are urging the district judge to overturn retired Judge Vaughn Walker's ruling that marriage is a constitutional right for same-sex couples based on new evidence that has come to light recently, pointing to Judge Vaughn's bias because of his own long-term same-sex relationship.
Play devil's advocate here. Let's say the judge in this case was a heterosexual, ruled that Prop 8 should stand as is. Would you have attempted to use the same type of legal argument and appeal that as a married straight judge would show bias on this?
The ProtectMarriage.com legal team representing the California marriage amendment in federal court filed a motion on Monday to vacate the court decision that struck down Proposition 8. The motion argues, among other things, that the currently retired Judge Walker violated federal law by not removing himself from the case. In other words, Judge Walker should have recused himself. The motion also argues that Judge Walker's impartiality was violated due to his 10-year same-sex relationship, his failure to disclose that relationship at the beginning of the case, and his failure to announce whether or not he had any interest in marrying his partner. In other words, they're saying that his ruling could have been beneficial to what he wanted to do in his own private life, and therefore he was not being fair when he judged this case.
It was an open secret during the trial that Walker chooses a homosexual lifestyle himself. What wasn't known until after he retired was that he's been in a 10-year relationship with another man.
Last August, Judge Walker ruled that the Proposition 8 marriage amendment that defines marriage as between a man and a woman was unconstitutional and determined that same-sex couples do have the right to marry. Earlier this month, Judge Walker opened up about his own personal sexuality, but said that he saw no reason to remove himself from the case.
It will go to the Ninth Circuit Federal Appellate Court in California. And meanwhile, it's important that the rest of us who believe in fairness make the same case for the freedom to marry in the court of public opinion that the lawyers made in the court of law.
Well, it would be up to the Ninth Circuit to actually send it back to the district court, but that is correct. It would be randomly reassigned to another federal court judge, and again, it would be randomly reassigned. They would not have any right to choose it. But a lot of people are arguing that this is analogous to if a judge was deciding a case just based on marriage, based on whether two married people should have the right to deduct their insurance payments at the same time. And you could argue, well, that judge is married, or that judge might get married, so they have a vested interest. So people are saying that even though he might have had a same-sex relationship, it's still such a general, broad issue that he should not have recused himself. So all we can do is wait and see what happens. Again, there's been motions filed in the Ninth Circuit Court of Appeals, and hopefully they will be making their decision soon, and we will give you the update on the status of Proposition 8.
Today, we have moved one important step closer to marriage equality for all gay and lesbian couples across this great state. Make no mistake about it, Proposition 8 is hanging by a thin thread.
Thank you for watching The Legal Analyst, and remember, I am your legal analyst, Dr. Leigh Davis.